Once again, a very warm welcome to all of our attendees this morning. So, this morning, we want to discuss safety files. What is a safety file? Well, in terms of Section 8 of the Occupational Health and Safety Act, it basically stipulates that an employer or the owner of a business must provide a safe system of work in order to provide and maintain a safe working environment. Now, this system of work or a documented management system must include items required by legislation as well as what is in line with the scope of your company. Obviously, we know we're discussing plumbing, but many plumbers out there are also in different types of construction work. And so you perhaps are doing demolishing or building as well. Perhaps you're doing refurbishing of buildings included with the actual plumbing. For some of the plumbers that I have worked with, you're doing electrical work as well. And so the safety file that you design is not just in line with plumbing. You see, it works in conjunction with the OSH Act, but as soon as we do plumbing, we have scope-specific safety files that need to be designed. And one of those is obviously plumbing, as IOPSA is really trying to assist you with designing of documentation that is specific to plumbing. But we are also trying to assist those plumbers out there who are doing different types of work as well. And so we've designed safety files for you based on demolition, based on electrical work, as we mentioned earlier, as well as some of you getting into water reticulation, which comes or forms part of plumbing, but it's a little bit more different type of plumbing that is involved there with lifting, cranes, things like that. And so we would like to encourage you, please reach out to us if you are doing any other types of work that are included in your scope of work other than plumbing. And perhaps we can see if we can get some documentation for you or even some templates to assist you in having a safety file that is not just scope specific, but that is also compliant with the relevant regulations. Now, a safety file is a documented body of evidence that provides a convincing and valid argument that this piece of legislation, Section 8, is being upheld, that a safety system is adequate as well as safe for any given application or any given environment. Now, this documentation, generally in paper or digital format, comprises the major portion of your safety file. So in other words, it's the proof that your duties are being fulfilled in terms of the OSH Act, specifically speaking to you as employers. But as an employee, it is your responsibility to keep these documents updated. See, you are the one that has to take the file, read through the file, understand the file, go through all the safe working procedures and risk assessments, etc., and then sign it off to show that you accept what is being done. Now, the very first piece of legislation in terms of Section 7 of the Occupational Health and Safety Act states that you should have a occupational health and safety policy. Now, this health and safety policy outlines your company's goals as well as your mission statement for achieving a safe working environment. And this is for your company in general. It's not going to be site specific. It will just be a health and safety policy that you as a company are going to promote in order to achieve compliance to the OSH Act. For one, it must be signed by the CEO. It must be prominently displayed at your workplace, but it must also be located in a copy form and signed by the CEO in the health and safety file as well. Some clients, we have noticed this on some sites, they are requesting that you put a register of attendance at the back of the health and safety policy or included with the health and safety policy, just so that the employees who come to site sign that they accept the actual policy of the company. Now, this is just generally accepted out in the health and safety industry. It's not every site that you get to that's going to require this, but we thought this would be a very good practical way of showing our convincing evidence from a company and proving that our employees take the responsibility seriously by including this attendance register, going through their health and safety policy and signing that we accept what the policy says. So perhaps if you don't have something like this, just add an attendance register to your health and safety policy for when you get to site, just showing that commitment from your employees. Again, it's not a legal requirement, but it has become industry standard or best practice for many health and safety guys out there. Another document that you will find is your risk assessments. This is probably one of the most important documents that you will going to find in your health and safety file. And this is because it guides and directs almost all the other documents in your health and safety file. You don't generally have a baseline risk assessment in your file when you go to site. It all depends on what scope you are fulfilling for that site. So for those of you who are doing just private work out at homes, perhaps going to do geyser installations or checkups, or perhaps just normal plumbing inside of a home, you would still have your normal issue-based risk assessment. So this is for each task or issue that you're performing, and this can be in the safety file for your plumbers in the vehicle, and they would then understand what the risks and hazards are based on what the work they are performing for that specific task, not necessarily an overall baseline risk assessment for all the tasks you perform as a company. Now, if you are performing the duty or the scope of work as a principal contractor or a main contractor on some sites, you might be requested to issue a baseline risk assessment to your client. The reason for this is you are going to be performing maybe a lot more work on that site, and they will request an overall risk rating for your company. So this baseline risk assessment outlines everything you do as a company, and that would include your plumbing or your electrical, or perhaps you're doing refurbishing as well, or building maintenance. It would go into more detail about everything that you do as a company, but you will still be requested to put forth an issue-based or a task-based risk assessment as well. And this is because these generally expire after a few months. And so when you get to site, what you are starting with in the next 3 months is that specific issue or that specific task you are performing. And you will need to have a site-specific risk assessment. You see, a baseline risk assessment can't generally be site specific unless you are running the entire site. So why is this so confusing? Well, a baseline risk assessment for a construction site will be site specific because it takes into consideration the actual site. But a baseline risk assessment for your company is company specific. So your issue or task-based risk assessment then would be the document you would update as more site specific. In other words, going to your client and taking into consideration the risks and hazards that you would find on that particular site, as well as for the particular scope you are performing. And we've spoken about this before. Your risk assessment cannot be the same for every site because every site is different. In fact, almost every task you perform, although it's the same installation of plumbing or changing of a geyser or an installation of a hydroboil, the task sounds the same because the description is the same, but you might have to drill into concrete, drill into steel. There might be some welding that is involved. There might be chasing or chopping of concrete, depending on the environment that you are in. So installing a geyser might just be one aspect of the task you're performing, but how do you get to the point of installing it? There are so many other methods in order to put into place. And this is what we call task or issue specific as well as site specific. So that's a very important part of your health and safety file. Now, continuous risk assessment helps clients as well as safety professionals to see whether you're continually assessing the risk that you have noticed on site. And this can be in the form of DSDRs, job observations, job hazard analysis forms. Basically, what this does is it adds strength to your issue-based risk assessment. Now, let's give you an example so that it makes it easier to understand. If you are installing a geyser or a hydroboil on site, and you've done your task and issue-based risk assessment, you've done your walk around on the site, you've made it site-specific as well as task-specific for what you are performing. And then when you get to site, you realize you actually need to use a ladder in order to reach some sort of access valve or perhaps a stop valve, or you need to install an electrical cable in order to have an isolator that is close enough to your geyser. And now you think, well, I didn't include this in my issue-based risk assessment. What you can do now is use a continuous risk assessment, such as the DSTR, to outline what is that task-specific identification of risk. And then you include that and update that in your issue-based risk assessment at a later stage. But at least assist you now on site within the next few minutes to be able to start that job, showing that you have already identified the hazards and assessed the risk. Because if you had to get the risk assessor out now to change that task, you might be wasting time. It could be adding too much cost to the company. And that is why safety professionals always request that you have these three items in your files. The baseline risk assessment as a major risk assessment for your entire company, perhaps kept in your offices, but then inside your health and safety file for that site must be an issue or task-based risk assessment, as well as the various continuous risk assessment forms that you would need. Now, aside from your risk assessment, every time a critical activity or any area has been identified, you need to establish safe working procedures or safe operating procedures. Now, these can be standard safe work procedures or safe work procedures, however you are designing your actual documentation. But it goes into a lot more detail, like a method statement, and it also includes not just the task that is being performed, but any personal protective equipment that is mandatory for that specific task, included within the actual tools, machinery, or equipment that you are actually using. It will go as far as to ask you if there are any licenses, training, or permits you need in order to ensure that this work goes according to plan. So this safe work procedure can either be done on site or it is done ahead of time if you know what documentation you should have. Now, for an instance, you might get to site, and as we mentioned earlier, you're setting up your ladder in order to work, but now you need to access a higher area of work, an elevated working platform. And now you would see the need for a full protection plan for working at heights training, and your safe work procedure would now change. You see, it would change to being working at heights, and it would include having the training of working at heights. It would include documentation such as your fall protection plan, a working at heights risk assessment, as well as your review and monitor plan for both of those documentations. And then you take a look also at the necessary equipment that is needed, the adequate safe access to that area, as well as fall prevention, fall protection, or fall arrest systems. So your safe work procedure helps you to outline the exact method of how you are going to perform this work, as well as all the resources that are attached to ensuring that work gets done correctly. And so this is generally based off of your actual risk assessment. We take the risk assessment, we identify those tasks, and we design safe work procedures that assist us in understanding exactly what needs to be done. Then we have appointment letters. Again, it will be scope specific. So if you perhaps are on site and you are the subcontractor, well, then you're going to be appointed as a subcontractor by the principal contractor. And this is what we call a 7-1 CV, or an appointment as a principal contractor or a subcontractor. You will then get a mandatory 37.2 agreement between the two of you, showing that you are an employer in your own right and you have to employ your own staff. You will then appoint people such as a 16.2, someone who's going to be a 2IC on site for you. Perhaps you, as the owner, are going to go to site yourself. And so you're just going to have a resolution as a 16.1 to say you accept responsibility for your staff on site. But then your client or principal contractor might appoint you in a different capacity. So you might be appointed as what they call an 8.7 from the construction regulations, as a construction site supervisor. And so you might fulfill more than just one responsibility. Perhaps you're not going to go to a construction site. Perhaps you're just going to be working in a normal environment with no construction work. Maybe this could just be maintenance of the actual plumbing work, such as changing of taps and things like that. Or perhaps you would then need to adjust your appointment letter to an appointment of legislation or piece of legislation that is not tied to construction regulation, but more to the Occupational Health and Safety Act. So it's really important to know and understand where the appointments come in. Are these appointments in conjunction with legislation? Does it have legislation attached to it? For one, we can speak about a first aider. First aider is appointed in terms of your general safety regulations. And so it's not tied to construction or tied to the OSH Act. A first aider is tied to your general safety regulations for those who have more than 5 to 10 employees. If you have 5 employees, you have to have a first aid box. If you have 10 employees, you have to have a qualified first aider. And this goes to show that we need to really understand how many people are going to be on site, the scope that we are performing, and then ensuring the necessary competencies for those persons that we are actually appointing. And perhaps you might think to yourself, well, the work that I'm performing doesn't need a first aider because I'm only 2 people on site. Now, remember, a client is allowed to request that you go over and above the law. You see, what they can't do is say, you've got 20 people on site, you don't need a first aider. Well, that's incorrect. According to the law, if you have 10 people, you have to have a first aider. That's the minimum requirement. But you are allowed to take the principle of the law and apply it to best practice. In other words, your client can request that you have a first aider appointed, even if you only have 2 employees on site. And this could be because of the actual risk assessment. So they must back it up with some sort of proof, or they must give you, how do we say, a little bit of a valid argument as to why you should have this appointment. It can't just be because they feel that you should have one. It should be in line with your risk assessment. If they notice that your hazard identification and risk assessment program has noticed something that is very high, then they might request that you have a first aider. And this should be in discussions before we even start the site, which is a huge thing that is lacking on many of our sites. Communication is not there at the beginning in order for us to be able to put forth the best effort in ensuring all our resources are correctly attached to that task. But again, learn from the principles of the law. If you know you need one for 10 employees and you've got 8, why not train up one in any case? Yes, it's not a legal requirement, but do you really have to wait for the law to tell you to do something before you see that it's in your best interest to do it, especially for your employees as well? Now, when we take our employees to site, one of the things in terms of Section 13, that is the duty of the employer, is the duty to inform. And this information should come through on anything that is in the interest of health and safety. So we need to inform our staff on things like the emergency procedures for the site, where the location of first aid stations are, who the health and safety responsible person is, including those specified by legislation, such as who the 16.2 is, who the immediate manager or supervisor is, who the first aider is, who do they report injuries or unsafe conditions or unsafe acts to, and also what is the procedure for reporting these injuries or unsafe conditions and acts. We need to inform them on how to use PPE, inform them on the right to refuse hazardous work, inform them on the hazards based on the risk assessment, inform them on the reasons for each health and safety rule that you find on site. What about giving them the information on their specific role and responsibilities, or even their scope of authority, their job descriptions? What are they meant to be doing? And so employee orientation or duty to inform in terms of Section 13 is extremely important because this brings over a very key aspect of health and safety management, which is communication to our employees. We then take a look at inspections. Now, this is something that has to be done daily, weekly, monthly, and these are at different intervals depending on what you are going to be using. So it's generally taken the form of a register or a checklist sort of system, as well as certain reports that need to be done. So inspections need to be carried out by your health and safety reps, by your supervisors, or where prescribed by regulations, such as if you have a fire extinguisher on site, you should be inspecting it just to see that it's still adequate to be used every single month. Uh, Power tools or portable electrical tools, such as your drills and grinders, need to be inspected every day or every week, depending on the actual scope of work that you're performing. Your ladders need to be checked regularly. So, same as your hand tools, your fall protection, your scaffolding. And you also need to know what are the intervals in order to inspect these things. You see, you might have a template document to inspect housekeeping monthly, but in the safety specification, your client is stipulating that it must be checked weekly. And again, what is required by law? Well, very few things are required by law in terms of inspections for occupational health and safety systems, such as scaffolding, has to be checked every single week or every 7 days. It has to be checked after there's been inclement weather. It has to be checked if anything has changed on the scaffold. And it also has to be checked after an incident or accident has occurred. And so that's prescribed by law. But what about hand tools? You see, hand tools, if you're not in the construction regulations, what is your regular inspection? How often is that being done? And do the hand tool inspector and employees know when it needs to be done? Now, another thing that will fit into your safety files are your medicals. Medical, obviously done by an actual prescribed general practitioner or a health and safety doctor, someone that is allowed to perform a medical. And you might be required to have pre-medicals, baseline, periodic, or exit medicals, depending on the industry that you're in. Generally speaking, and I'm saying generally because it might not affect every one of you, but most of the plumbers that we've worked with, you need to have a medical every year. This is a construction medical in accordance with an Annexure 3 document where it outlines the scope of work, the responsibility of that person, and it also includes things like, is the person working in a confined space? Are they working at heights? Are they working in noisy areas? Do they have any chemical exposure? And so you need to have that information on hand when you request a medical. Far too often we see medicals coming through and they've got the medical for construction, but it's not ticked off for working at heights. And so we cannot allow that person to work at heights. So before we go and get a medical, find out what we are going to be doing on site, plan for future, not just for the task you're doing. Remember, a medical lasts an entire year. So put a little bit of thinking into it. What tasks are you going to be performing as an employee or as an employer for your employees in the next year? Is there something specific that you need to explain to the doctor about in order for them to be competent and also ensure that they are fit to work in that specific scope? Now, according to your Section 24 of the Act, as well as Section 25 of the Occupational Health and Safety Act, there are certain reportable incidents as well as reportable occupational diseases that must be reported, as well as the recording. So you have recording and reporting of incidents and accidents, and these documents should also be kept in your health and safety file. You will have documents on emergency procedures. Now, this is where the duty to inform in terms of Section 13 comes in. You're going to inform your staff on emergency procedures, access and egress, emergency exits, but you also need to have the procedures for it. You see, it must be documented and not just verbal. This is all normally forming part of your induction program. And so there must be some sort of documented proof that is also signed by each employee. So all your emergency procedures would include fire precautions, as well as your emergency evacuation precautions and your first aid. How are you going to get that person from where you are to a safe environment? If there is a hazardous chemical spill, what is your procedure on ensuring that that spill does not become an environmental hazard? And all of these documents should also be in your health and safety file. And then if you are appointing a contractor under yourself, so you are not the contractor only for your client, but you need to appoint a contractor to come and assist you with something. Perhaps they're going to do some scanning for you. Perhaps they're going to do core drilling or building scaffolding. They are your contractor. And so you need to manage that contractor. You must have your own agreement in place. You must ensure they have their COID registration according to Department of Labor or FEM. They should have their own medical certificates. In fact, all of this means they need to have their own safety file with all the documents that you should have with a different scope of work attached to it. And then please remember, COVID-19 is still with us. We must ensure that we have a COVID-19 management plan. We need to appoint a COVID-19 compliance officer. Our COVID-19 plan must include the items that are outlined in the OHS C19 regulations that have been promulgated or taken out of the Disaster Management Act of 2002. Please ensure your awareness training is up to date, as well as the adequate posters for hand washing, coughing, sneezing, or your screening. And just ensure that all of this is in place, because COVID really is assisting us with the health aspect, as well as in accordance with our hygiene regulations that we need to abide by. So if you need help with anything, perhaps you're going to go to your health and safety representatives, set up your committee. And if you do have more than 20 employees on site, or 20 employees in general, you have to obviously appoint your health and safety rep. And so all of this documentation will also then be inside your health and safety file. And this will then move along with your committee meetings that need to be performed, the monthly meetings and monthly audits that need to be done. And your health and safety committee knows and understands their responsibilities. They will carry it out, but give them the resources in order to do it. Thank you to all of our attendees this morning. We look forward to seeing you next week.